So do you remember when the news broke saying that Equifax had been hacked and some 130 million people's identity and credit information had been spilled out to a bunch of hackers? One of the first things that a lot of people did is they went to Equifax to fill out a form on their site that said that they'll tell you whether or not your information was compromised. And it told me, yeah, your information was probably compromised. They don't tell you that it definitely was, but they tell you that it probably was. And then they offer you a bunch of free services to apologize for it. Now, originally it was a free service for a year, and then you'd have to start paying for it after a year. They were trying to make money off of it, which is just brutally pathetic. There was so much outrage about that, they changed it. But then people started noticing something else in the fine print, that by agreeing to this free service, you were then agreeing that all claims that you had would be decided through arbitration. So that's what we're going to talk about today, arbitration. Now, they eventually took that line out because, again, there was a ton of outrage, but arbitration is now coming to the floor of the United States Senate. The reason is that Elizabeth Warren's Consumer Financial Protection Bureau created a rule recently that said in one of these little contracts like this that a big company creates with a small consumer for a small product, you can't put these arbitration clauses in there. These arbitration clauses were basically rip-off clauses. It allows these places to rip you off and gives you basically no remedy, because you have to go through years of kind of this costly arbitration process through an arbitrator that, you know, they certainly have some influence over. Years of this process to try to get a refund on like a $30 thing. And only a complete maniac would go through that process, or somebody who's just doing it for the principle. Everybody else is like, I'm out $30. I just got ripped off. And Wells Fargo and Equifax and places like that build their entire business models, or significant portions of their business models, around their customers just saying, fuck it, just take my $30. I can't deal with this anymore. And so the CFPB rule said, no, you can't do that. And first, credit to the CFPB here, because that's how you ought to write a rule. You know, the way that a lot of kind of technocratic liberals would have written the rule, it would have been pages and pages and pages about when it would be okay to have one of these arbitration things, or what size the company, and what this and what that. And it would be so extraordinarily complex that the companies would find ways around it and be useless. Whereas the CFPB did something very smart. They said, we're going to make it simple. You can't do this because it's just for the purpose of ripping people off. If you rip people off, they can join together in a big class and they can sue you. And that is the threat, not necessarily regulators. It's the threat of this class action lawsuit that is going to persuade companies like Wells Fargo to say, you know what, maybe it isn't that smart for us to just, you know, set up fake accounts for people, or whatever new version of a scam they're doing. And this is one of those rare issues that actually really matters to you, because everybody deals with a bank. Everybody deals with these credit agencies. Everybody is used to going to the bottom of the website and saying, I agree. You click I agree, and you go to the next page. Nobody has ever read that disclaimer all the way through. And so what the CFPB is saying, you can't have a rip-off clause in there. You can't have something in there that allows you to be ripping this person off. And if they don't have that clause in there, then they're afraid that they're going to wind up on the ass end of a class action lawsuit, which is going to change their corporate behavior. Under the current rules, because CFPB rule isn't in place yet, they can just say, no, you can't be part of this class action lawsuit. You signed this arbitration clause. So obviously, this is one of the biggest priorities for business right now, to get this rule overturned. There's a process in Congress known as the Congressional Review Act, which allows, within a certain amount of time after a regulation is finalized, allows Congress to overturn it, just get rid of the regulation. The House has already voted to overturn this CFPB regulation. And while everybody has been focused over here on Obamacare repeal, McConnell has been quietly trying to build up all of the votes to get the CRA through the Senate. Now, all you have to know is that McConnell wants to allow companies to use arbitration to protect themselves after they rip you off. And the problem he's having so far is that he doesn't have the votes for it just yet. Lindsey Graham, ironically, is a firm and public no on this. And this is, and it's ironic because they have been using kind of Graham Cassidy as the cover to get this thing through. John Kennedy, backbench senator from Louisiana, Republican, is actually on the fence on this. Susan Collins and Lisa Murkowski, who are always on the fence, are on the fence on this. I talked to Susan Collins yesterday. She said she still hadn't decided. Rob Portman from Ohio has not said publicly where he stands on this. I spoke to Senator Johnny Isakson to try to get his take on why it is he opposes this CFPB rule.
The ability to arbitrate is very much pro-consumer. There are cases where people don't want to waive their right to have an attorney. I understand that. And they can waive it if they want to. It's not ever taken away from them, but it's a good way to expeditiously deal with a grievance on a contract.
In general, Republicans don't like the courts. They don't like trial lawyers who tend to be Democrats, and they don't like the courts. They say, they take too long, the appeals process, you get gummed up and you have to pay all these legal fees. And most people would agree with them on some level that the courts are a pain in the ass to deal with. The problem here is that their alternative means that the big guy always wins.